Now, let's venture into biofeedback terminology and explaining them a little bit here. Many of the words used in biofeedback software, such as therapy and treatment, were originally designed to accommodate terminology used by the licensed medical fields and to accommodate their insurance billing codes. Biofeedback is deemed a part of these licensed fields' other therapies and treatment programs that they can administer, and this is a good thing for biofeedback. For that reason, the terms therapy and treatment are used by them for the larger scope of services that they provide, because they can practice either medicine, acupuncture, chiropractic, etc., in addition to biofeedback. Therapy and treatment are therefore referred to on some program names. However, because biofeedback has proven to be safe with no risk of causing harm, licensure is not required to legally practice biofeedback. Separately, the use of the terms therapy and treatment have been ruled to infer the practice of medicine. Therefore, if you are unlicensed and only certified as a biofeedback specialist, you should avoid the use of those words. It's our responsibility to know what we can legally language or put in writing describing our services regarding the different button names on biofeedback software. According to Jim Turner, an attorney at law, there are 5 words that should be avoided by unlicensed but certified biofeedback specialists in reference to their services or diseases or conditions. Number 1, treat. Number 2, mitigate. Number 3, cure. Number 4, diagnose. Number 5, prevent. However, many non-licensed certified practitioners have enjoyed a successful career in biofeedback, and they use the following verbiage to observe these legalities. In general, these terms are what we recommend in place of some of the therapy button names because of issues expressed by licensing boards in the past. Use the word train instead of treat. Licensed fields treat, biofeedback signals train or retrain responses. Treatment infers licensure, and if you don't hold a license, it's best to avoid this word. Substitute the use of the term therapies with programs or training programs. Some states interpret therapy as inferring treatment, and those in the certified field avoid the use of this word so that they're not construed as practicing medicine without a license, unless they're working under a licensed professional, of course. Substitute the term client for the term patient. Only the licensed fields see patients. And the use of this word can be construed as you're portraying yourself as a licensed person, unless you're working under a licensed professional and are seeing their patients. You would want to use the term educate instead of prescribe. Because lifestyle changes are a personal choice, clients make their own decisions based on education. Another reason that the authorities are adamant about unlicensed professionals not portraying themselves as providing therapy or treatment is because unlicensed professionals are unable to provide emergency medical care. In a state of emergency, people are under stress. If you've presented yourself as someone who provides treatment and cannot provide medical care, they may think to call you instead of obtaining emergency care in a timely way. This is construed as potentially causing them harm. For this reason, in some states, other licensed professionals, such as acupuncturists and chiropractors who are able to provide some forms of treatment, must state on their outgoing voicemail messages that if this is a medical emergency, please hang up and dial 911. However, unlicensed certified biofeedback specialists do not need to place this message on their outgoing voicemails, as this may falsely infer licensure in another field. If you have not claimed therapy or treatment in your services and are using an informed consent form, then you have not falsely portrayed yourself from the start. Now, here are a list of frequently asked questions which we've had feedback from Jim Turner, an attorney at law. His email is jim@swankinturner.com. That's JIM at SWANKIN-TURNER.com. His office number is area code 202-462-8800, and his location is in Washington, D.C. Here are the frequently asked questions and his responses. He began by describing the regulatory processes in America. And what he stated was that one thing that's important about the EPFX is the lack of harm associated with it. That is the strongest argument we have in being safe from the authorities. There's no evidence of harm that's come from the device. The regulatory framework in America is structured with several different sources that bring impact on an individual who wants to use the device, either as a practitioner or as an individual who wants to use it on themselves. There is the federal level, which is the FDA, and then the FTC, which is the Federal Trade Commission. Both of them essentially are regulating claims made by manufacturers at this point. Because the EPFX is safe and has a 510K, it can be used as long as it's used for the stated purposes cleared by the FDA. The way the FDA knows that you're using it for its designated purpose is to avoid conveying the notion that you're treating anyone for a disease or a condition. If you can avoid making that claim, you're in a very strong position with relation to the FDA. And the FTC follows the FDA's regulation of advertising, so if you're compliant with the FDA's clearance for the intended use of the device, you'll be in sync with the FTC as well. The next level of regulation is at the state level. There are two kinds of regulations at the state level. One is by the health boards. If you're a licensed practitioner in a state and you use biofeedback, your licensing board regulates your use of it. So it's wise to check if your board has regulated any issues surrounding the EPFX. On a separate note, if your licensing boards find it necessary, they can raise questions about what you claim or advertise or your competence. If you're certified in biofeedback and not making health claims, even the license boards will have difficulty blocking you. If you do make health claims, you actually are not regulated by the boards per se, but the board may refer their complaint to the state attorney general, asking them to bring a charge against you for the illegal practice of medicine. If you make the claim, I'm treating somebody for X, Y, or Z, the state medical board could ask the attorney general to intervene and discipline you, or they can ask your own board to do so if you're licensed in another field. The closer you look like you're practicing medicine, the more vulnerable you are to restrictions and actions from the authorities. Now, the next question was, are licensed professionals who don't write prescriptions for drugs able to legally write prescriptions for biofeedback, and do the laws change from state to state? And the response was yes. The laws do change from state to state, but there are no problems in writing prescriptions for biofeedback. Anything that you can say to a client or patient, you can write down, and that is what is being accepted as a prescription. The prohibition is for writing a prescription for a drug, which is heavily regulated. The two types of prescriptions, drugs versus for a biofeedback device, are completely different in nature. There are prohibitions on writing prescriptions for drugs, especially narcotic drugs, but there are no prohibitions on writing recommendations to obtain a biofeedback device. The next question was, does California have more lenient standards for prescription writing? And the response was that even across the laws are even across the country. The way most people think of prescription writing is with regard to drugs. And then there's the DEA and narcotic prescription writing. There's virtually no regulation in the states to control what these things are about. It's possible that a health board might adopt a rule for its profession. That's your responsibility to check. He would have been surprised if there was legislation that specifically addressed this kind of prescription. So he was not under the belief that California has any more stringent or any more lenient laws.